Morning, Your Honors. I'm Charles Michaels, and I represent the appellant in this matter, Kim Williams, and I'll reserve 4 minutes for rebuttal.
That'll be fine.
This matter originates from the Chancery Court of Ray County, Tennessee. The appellant filed suit against the Lewis Living Trust, the Preservation Trust, two of her brothers, David Lewis and William Lewis, and attorney Norm Sabin. The main issue in the lawsuit was whether David Lewis, acting as his mother's attorney, in fact, could modify his mother's trust in a way that didn't follow her known estate planning wishes, and as to Norm Sabin, whether he negligently represented to Kim Williams the nature of the irrevocable preservation trust that he was creating for Elizabeth Lewis. In two separate summary judgment orders, the trial court ruled against Kim Williams as to William and David Lewis, finding that regardless of whether David Lewis breached his fiduciary duties or breached his duties as attorney, in fact, to Elizabeth Lewis, a no contest clause applied to Kim Williams' claims. As to Norm Sabin, the trial court ruled that Williams could not establish negligent misrepresentation because Sabin advised Kim Williams to obtain her own counsel as it regards to Kim Williams creating her own trust. On April 12, 2013, this court overruled the trial court's ruling as to the trusts and David Lewis and William Lewis, finding that simply because Kim Williams filed an action to contest the trust based off of a breach of duties as an attorney, in fact, and seeking an interpretation of the trust, doesn't mean that she was automatically kicked out of the trust itself, and therefore the breach of fiduciary duty claim should proceed. The court did note there was nothing in the record that indicates that the trust created by Norm Sabin follows Elizabeth Lewis's known estate planning wishes. And in this appeal, Kim Williams seeks to hold Norm Sabin liable for that creation of the irrevocable preservation trust, despite the lack of any evidence that it followed Elizabeth Lewis's known estate planning wishes.
What connection does Kim Williams, your client, had with Norm Sabin, the attorney?
She had no direct relation with Norm Sabin other than as a beneficiary of the Lewis Living Trust and then the irrevocable preservation trust that Norm Sabin created.
Did he owe her any duty?
The cause of action for negligent misrepresentation exists in Tennessee, and in cases it's been applied to non-clients of the attorney when the attorney provides information to them that is false, and they justifiably rely on that information, and they end up being injured as a result.
Who was the information provided to?
Could you repeat the question?
Who was the information provided to Norm Sabin? Who did he provide information to?
In this case, he provided the information to Kim Williams. Any further questions on that?
And what was that information he provided to her?
While the irrevocable trust was being created, and while there were amendments to the Lewis Living Trust, and apologize, this happened after Robert Lewis died. He and Elizabeth Lewis were the original trustors. So while creating that irrevocable trust, which consisted of Elizabeth Lewis's contributive share to the trust, he and or his employee, Jacqueline Walser, advised Kim Williams that the irrevocable trust was going to follow the terms of the Lewis Living Trust, that after Kim Williams requested all of her parents' estate planning documents, that those documents were provided, and after the preservation trust was created, that the distributions from the trust were going to happen at the time of the death of Elizabeth Lewis. Those representations turned out to be false because the Lewis Living Trust required all the assets to be distributed at the death of Elizabeth Lewis, and in the irrevocable trust, the assets were not to be distributed at the death of Elizabeth Lewis. They were to be continued to held in trust so that another brother, William Lewis, could run the business for so long as he decided he could keep the income And as this court ruled in April of 2023, due to the language in the trust that Sabin wrote, he potentially could have sold off all the assets and kept the proceeds for himself.
Okay.
All right. Going back to that on the preservation trust, again, the negligent misrepresentation claim, Ms. Williams has to establish that Sabin was acting in the course of his profession. He provided that false information. Ms. Williams justifiably relied upon it, and that Sabin didn't act with reasonable care or competence in communicating the information. Regarding Ms. Williams' justifiable reliance, which is what the trial court looked to, Ms. Williams was requesting that Sabin establish a trust on behalf of Ms. Williams because she was in the process of getting a divorce. So when she received assets from her parents' estate, she could set it up in a way that her son would be protected if anything would happen to her, that his father couldn't access the money.
Is there a client-attorney relationship between Sabin and Kim Williams?
There was not. After, at some point, about 6 months, I believe, prior to the creation of the irrevocable trust, she was told by Norm Sabin to reach out to an attorney in Colorado to create the trust that she was seeking. And then when this irrevocable trust was being created, she was advised after the trust was completed that Norm Sabin couldn't represent her because there was a conflict of interest between her and her brother David Lewis, and that up into in the month prior to the completion of the irrevocable trust, Sabin had been permitted to talk with Kim Williams regarding the administration of the trust based off of a limited waiver, I guess, of the or David Lewis was allowing Norm Sabin to communicate with Kim Williams regarding the trust. Again, Kim Williams was never advised that at the time until after the trust was created. And also when she was told that, it was explained away that David Lewis was going to be handling the administration of the trust going forward, so there was no reason for anybody to be communicating with Norm Sabin at that point. So he never said, you should consult an attorney with regards to your interests under this trust that I'm creating. It was, you should consult an attorney in Colorado as regards to this trust that you want to create to protect your son. And while there is a conflict of interest, I've been allowed to talk to you by David Lewis, but going forward, there's no need for that because I'm no longer going to be involved in administrating the trust. There was a separate issue regarding that. Because he was creating an irrevocable trust and Kim Williams was a residuary beneficiary, per TCA 3515-813, she was required to receive either a copy of the trust within 60 days or a summary of the trust showing the estimated assets of the trust and what had to occur in order to receive her distribution under the trust. That's Ms. Williams' position as to how she was injured by these acts. Had she received that information at that time, she could have filed some action, whether it be to remove David Lewis as the attorney in fact, or that would have been the main one, or otherwise enjoin the creation of the trust, depending on when she was told about the nature of what the provisions were going to be. But instead, she didn't learn about the trust until she didn't learn about the distribution provision of the trust until approximately 18 months after the fact. And at that time, the statute of limitations began to run on her ability to contest the trust, so she was required to sue David Lewis, the trust, to make sure she preserved all of her claims. And in doing so, she became subject to the no contest clause, which again the trial court relied upon in initially denying her claims. And by doing so, not only has she incurred significant attorney's fees, but also the trust itself incurred and was allowed to spend by the trial court in excess of $200,000 in attorney's fees. And from Ms. Williams' perspective, at the time all these statements were being made to her, the money then, or the Sabin, when he was creating this trust, he was doing so with either funds of Elizabeth Lewis or funds of the trust itself, which in essence was some portion of Ms. Williams' ultimate distribution was going to creating a trust that removed her right to receive the assets at the end of the day, and she was never told that happened until to contest it. Again, she had to file suit against everyone. I'll wait for rebuttal. Thank you.
You have your time for rebuttal. We'll hear from the appellee.
Good morning, Your Honors. I'm Bill Hanna from the Hamilton County Bar. I represented Norm Sabin in this case, and I now represent Mr. Sabin's estate in this case. This case involves a dispute between Ms. Williams and two of her three brothers about the distributions of their parents' estates and their inheritances. Now, this appeal, the appeal we're here on today, relates to claims Ms. Williams made against my client, Norm Sabin. Mr. Sabin was the attorney who represented Ms. Williams' parents in connection with their estate planning and estate administration. Mr. Sabin did not ever represent Ms. Williams. Your Honor, Judge McClarity, and the answer to your question a minute ago should be an absolute, unequivocal no. There was never any attorney-client relationship between Ms. Williams and Mr. Sabin. This appeal relates to only one of three claims raised by Ms. Williams against Mr. Sabin, that of what I'll call breach of fiduciary duty to non-client. Originally, Ms. Williams sued Mr. Sabin under two other theories: legal malpractice and unauthorized practice of law. Those claims were challenged by motions for summary judgment. She abandoned and dismissed those claims and did not appeal that dismissal. So we're here today only on one of the three claims she tried to assert. The court the claims against Mr. Sabin were first asserted in the second amended petition. The court allowed Ms. Williams to amend to assert claims against Mr. Sabin, but not against Mr. Sabin's law firm. There is no allegation in the second amended complaint that Mr. Sabin is vicariously liable for the actions of his firm or of any employee at his firm. As I said a minute ago, this appeal relates to the granting of summary judgment to Mr. Sabin on the breach of fiduciary duty to non-client claim. And as I also alluded to a minute ago, during the pendency of the case in the trial court, and actually during the pendency of the motion that this court is now considering, Mr. Sabin died. His estate was substituted as a party defendant. His estate assumed the positions taken by him and continued to prosecute the motion for summary judgment that is the subject of this appeal.
Mr. Hanna, before you go further,
Yes, sir.
you said to the second amended complaint there are no claims regarding employees of Mr. Sabin's law firm. I read the briefs and I see many references to what certain employees of the firm said or didn't say.
I think
Are you saying those are not before us?
Well, the only defendant in the case is Mr. Sabin. His firm is not a defendant in the case. There are allegations, and I know exactly what you're referencing. There are allegations about emails sent by an employee of the law firm and how Mr. Sabin is somehow charged with the representations made by the law firm's employee. I submit to the court that there was a very specific finding that Mr. Sabin is the defendant, not the law firm, and vicarious liability was not even alleged. Any way you slice it, Mr. Sabin did not make any misrepresentation, and Ms. Williams' reliance on anything Mr. Sabin said or didn't say, or the employee said or didn't say, was not reasonable. And that to bottom line it, the Chancery Court got this case correct after extensive review, and this court should affirm that ruling. As I said a minute ago,
Were there allegations that Mr. Sabin had false or incorrect information delivered to Ms. Williams?
if I understand the court's question, I don't believe so. Let me digress and tell you what specifically the facts were that she says were misrepresentations. She says, Ms. Williams says that she was falsely advised by an employee of the law firm, that's Ms. Walliser, not Mr. Sabin, that she was being sent a copy of all of her parents' estate planning documents.
Well, who was doing the work? Who was the lawyer doing the work for the law firm?
Norm Sabin. Ms. Walliser at that time was a law school graduate. She had not been admitted to practice. She was a paralegal in the office. It's undisputed that Norm Sabin...
Okay, so the lawyer doing the work for the law firm was Mr. Sabin?
Absolutely.
And if an employee of the law firm delivered information to Ms. Williams, is not Mr. Sabin, I'm not saying he's vicariously liable, but is he not responsible for the delivery of that information to her?
Well, he's responsible. He is responsible to make sure that his office is properly supervised, and he has responsibility under the rules of professional conduct for subordinate lawyers and for non-lawyer assistants. Yes, that's not contested. The first claim that Ms. Williams made that Mr. Sabin made any misrepresentation was that she was told she was being sent all of her parents' estate planning documents, and she claims that was false because the email conveying those estate planning documents did not also contain copies of two documents that her father had made handwritten notes on. She also complains that Mr. Sabin, through an employee of the law firm, represented that the preservation trust would track the terms of the living trust. And finally, she complains that she was falsely advised that upon her mother's death, distributions from the preservation trust would be made outright. So that's what we're talking about in terms of misrepresentations. And we contend that Mr. Sabin didn't make any misrepresentation, and that Mr. Sabin also did not intend for Ms. Williams, who was not his client, to rely on any representation he made, and that he was not aware she was relying, that any reliance by Ms. Williams on Mr. Sabin was unreasonable, that Ms. Williams did not repose trust or confidence in Mr. Sabin, and if she did, Mr. Sabin was certainly unaware of it, and Mr. Sabin did not assert dominion or control over Ms. Williams, and did not place special trust or confidence in him. A review of the record in the case indicates that the opposite was true, that Ms. Williams is a very sophisticated professional. I'll talk about that in a few minutes. And far from being dominated by Mr. Sabin, she was dismissive of Mr. Sabin and critical of his work. So it stretches credulity to suggest that she was relying on him to her detriment. Now, the court made focused on 2 points in ruling in Mr. Saban's favor on summary judgment, and I think they're instructive. At oral argument, right out of the box, the Chancellor asked the lawyers to identify the first time Ms. Williams was advised to seek her own legal counsel. And there was a discussion on the record during that argument, and it was established that it was uncontested that Ms. Williams was advised to seek her own counsel twice. She was advised orally to do that in a March 2015 meeting in Mr. Saban's office. And that was days, maybe a couple of weeks after Ms. Williams' father had died. And she was advised a second time in writing in an October 23, 2015 email that Mr. Saban was not representing her, that he could not represent her, and that she should get her own lawyer. That email, which is part of the record, even provides a recommendation to Ms. Williams for a lawyer in Colorado. That's where Ms. Williams lives. We've quoted in the brief this discussion, the oral argument that I think is very important. That's on pages 8 and 9 of the brief. We've also quoted in the brief on pages 10 and 11 the exchange I had with Ms. Williams in her deposition about when she was asked to seek her own counsel, or when she was advised to seek her own counsel, and she conceded that it was in that first meeting in March of 2015. The other key point that the trial court focused on in finding that that there was no special or confidential relationship established between Ms. Williams and Mr. Saban, or that Mr. Saban had developed any type of fiduciary duty to Ms. Williams, was the basis on which Ms. Williams claimed that a duty was created. In her deposition, Ms. Williams testified that the reason she believed Mr. Saban owed her a duty was not anything that Mr. Saban said or did, but was based on a conversation or conversations that Ms. Williams had with her father outside of Mr. Saban's presence. Mr. Saban was not a participant to the conversation. Mr. Saban didn't know anything about it. And the court below correctly found that no special relationship was created under those facts, and that it was unreasonable for the lawyer, or for Ms. Williams, to rely on Mr. Saban after Mr. Saban told her twice, at least twice, to get her own lawyer. Now, I'm going to jump forward in the interest of time. There's a case from this court that I think is instructive and on point. That's the Batten versus Commodity Trading and Banking Company case. I think it's a 2019 opinion from this section of the Court of Appeals. And it addressed a situation where you had a sophisticated non-client, a sophisticated party, where the lawyer in the Batten case represented the bank, and I believe it was the CEO of the bank, also got some advice or some guidance from the lawyer, contended that the lawyer owed him, the bank lawyer owed him duties as well. And that court stands for the proposition, that case stands for the proposition that when the attorney informed the plaintiff verbally and in writing to consult his own counsel, the attorney, by definition, did not intend for the plaintiff to rely on the conversation. I think Batten is dead on, and I think if you look at this case and the facts in this case, and the positions of the parties, the sophistication of Ms. Williams. I talk about this in the brief. She's a college graduate. She has years of experience in the finance industry. She passed 3 of the 4 parts of the CPA exam. She took the Series 7 exam. She's an insurance executive. She's licensed in Colorado to broker several different lines of insurance. She is not at all a shrinking violet, and she was not at all overshadowed by Mr. Saban. Further, she did not evidence putting faith and trust and dependence on Mr. Sabin. She evidenced the opposite. The record is clear that she said that Mr. Sabin was a nice guy, but he didn't pay attention to the details like she did. And she was dismissive of him. She said that he was dismissive of her, and she was skeptical of his work product. All of the facts suggest that there was no such confidential or special relationship such that Mr. Sabin should be imposed any duty to her. She was not his client, and she was also not in a special relationship. As I said a minute ago, the court below got this correct as to Mr. Sabin. The court's rulings in the Williams versus Lewis appeal are separate from what we're here on today, and if that case needs to continue, so be it. But as to my client, the lawyer who did the parents' estate planning, the result should be affirmed. Thank you, Your Honor.
Thank you. We'll hear from the appellant in rebuttal.
Thank you. Regarding the representation and the Batten case, in that case, they were discussing whether the bank manager or president, when he resigned, potentially was going to lose his severance pay. In discussing that with him, the attorney for the bank told him he should consult his own counsel as she was drafting a letter for his resignation. That's not comparable to this case because Norm Sabin simply never said you should seek your own counsel in regards to this preservation trust. Regarding the fact that Ms. Walliser made most of the statements as opposed to Norm Sabin, Sabin, first of all, he was the attorney representing the trust and had the authority to speak with Ms. Williams. And second, he was included on those emails, or a number of them. And while the rules of professional conduct don't create per se standards of liability, courts have said they are certainly standards that can be looked to when determining liability. And Rule 4.1 states that in the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person. And then in the comments, it notes that a lawyer is required to be truthful when dealing with others on a client's behalf. But a misrepresentation can occur if the lawyer incorporates or affirms a statement of another person that the lawyer knows is false. In this case, Norm Sabin knew or should have known that the statements Ms. Walliser was making to Ms. Williams were false. He had a duty under the rules to correct those statements, and he didn't.
Did the trial court find, if anything, did the trial court find as to whether or not her reliance was reasonable or not?
The trial court, I believe the wording was, it was clear that Norm Sabin had advised her to retain her own counsel, and that Kim Williams couldn't have justifiably relied on Norm Sabin.
Based upon that she was told she should obtain her own counsel, that was the only basis for that?
Correct, I believe so. And there's also the issue of whether, I think the trial court referenced Kim Williams' deposition testimony where she said Sabin's work was sloppy. For the purpose of summary judgment, though, the facts need to be taken in favor of the non-moving party. And Ms. Williams also testified that she believed Sabin had a duty to her parents to follow their known estate planning wishes, which is correct, he did. So whether Ms. Williams thought that his work is sloppy or not, it's not relevant to whether, or that issue in itself wouldn't make any reasonable person believe that Norm Sabin would thereafter create a trust that wasn't in line with Elizabeth Lewis's known estate planning wishes, because the law is very clear on that. An attorney, in fact, can't create a trust that doesn't follow the known estate planning wishes. So, with that, are there any other questions?
Yeah, I hear none.
Thank you, Your Honors.
Okay. We appreciate your argument and your briefs. If you would, please recess court until 1:30 this afternoon.